What are cookies?
Hey, now we're
Oh,
live.
hello. Hi, this is Curt Barone,
And Brad Pinsky.
and we're here to talk about cookies. No, we're here for the first monthly and so weekly installment of Fire Law Roundup for 2025.
And now you've said cookies, and every one of our client or viewers is like, "Oh God, we should really get some cookies." So I'm
Well,
for it.
it's a funny, there's a process in order to get through YouTube, and you got to click on yes, I accept the cookies, and somehow it disappeared as I tried, and I didn't know if we were actually going to be able to get through here, but
Of course, every
somehow
time you
we
say
were.
cookies, I'm thinking food. Okay,
We
anyway,
got to
let's
hire an AV person.
let's get out to New York State. This is not my client necessarily. We have a volunteer firefighter. I guess this is kind of one step shy of arson or three steps shy of arson, but we've got a volunteer firefighter who's been he's facing 5 felony charges, right? For and the most minor of felonies, felony, but still felony charges for calling in false alarms to 911. This is in Dutchess County. This is the Hillside Fire Department, and allegedly it's a new member. Always seems to be right. The new members, whether they're doing false alarms or whatever, but or arson. But he called in 5 incidents between December 23rd and December 26th of 24. So pretty short, short time to do that. And he just called him into Dutchess County 911. He's saying that there's smoke coming, smoke showing, which is not a good idea. As we know, that triggers generally a structure fire alarm sequence, putting a ton of vehicles on the road. So this is dangerous stuff. In any event, he, also reported gas odors and report of smoke in the area, all different ones. But there's no way to really screen against this other than to ask people. But it occurs to me that when we meet with people, we should tell them that if you are under heightened scrutiny, that if you call in false alarms or you start a fire, you're going to jail.
Mm-hmm.
And being a member is going to make it worse, not better.
I think it's interesting that these were felonies. I think in most cases, most states, you'd have some misdemeanor charges here. This is a felony, and felony, the distinction there is over a year in prison is a felony. Under a year or under is usually a misdemeanor.
And it's
So,
New York State. No one goes to jail. Shy of murdering
well,
somebody, no one goes to jail in New York State. So I'm not saying
and
this kid
hence the
has to be
problem,
worried,
and
but
hence the problem. So,
yeah.
but I think it's interesting that it is a felony charge, and the other thing that kind of I thought was unusual about this one is when people call in false alarms, they don't usually do it from their cell phone. Now, it didn't say it was his cell phone. It said they were called in from a cell phone. So that which
Still,
opens a bunch of possibilities, especially around the firehouse, in terms of you grab somebody's phone and the nonsense that can happen in the firehouse. So hopefully that's not it. In addition, I don't know if the apparatus has phones in it and you're trying to use something to that nature. But I thought what was to me interesting is that each of these could argue that he legitimately saw. Let's take the first one, December 23rd, that he saw black smoke coming from the chimney. How do you debate that? You
yeah,
can't debate it. Maybe
and
there
I'm
was
looking.
smoke. Now maybe there was no need for the fire department, but there was smoke. Okay, go to the next one. Okay, that he noticed an odor of sulfur. Well, maybe he did. I mean, so it's to me, they're not the typical false alarms that you would expect.
Well,
He's
but an
23 years old, so
ATV
he's
in
not
a
a juvenile,
ditch.
but
Like the
the
third one's an
juvenile is
ATV in
just
a
gonna.
ditch.
Hmm?
The third
And
call he made is an ATV in a ditch. I
and
mean,
how do you disprove that? Because maybe
he
there
drove
was an
away.
ATV in a ditch. The kid fell over. He got on it and drove away.
Right.
So I mean, each of those, like my point, when people call in false alarms, when juveniles call in false alarms, there's typically there's not like a lot of thought that goes to it, and you can't really argue that it was somehow a mistake. in each of these, he could argue that it was a mistake.
You know,
I
and
thought I smelled
smoke,
gas.
right? And smoke makes sense, right? A fireplace, a chimney, a dryer vent, and maybe he's so new, right? That it's okay. So we'll give him the benefit of the doubt,
No,
right?
I'm not saying. I'm not saying. I just thought it was interesting that most of the time when we see false alarms, when I see false alarms,
Yeah.
it's somebody who reports a building fire when there is no building fire.
Right.
He didn't say building fire. He said smoke coming
Smoke.
from a chimney.
Right.
Okay. He said odor of sulfur, which could be any number of things. Okay.
Right.
And again, smell of gas. You know.
Maybe
So
maybe he's driving around trying to call anything he believes is legitimate to get the fire department there, so he gets some calls, right? But maybe he believes he saw it. Okay, that's more generous than I would have been. I would have hung him
no,
on
I'm not. I would be, if I was doing the investigation, I would be very skeptical of these, extremely skeptical of these. Okay,
Right.
on any given day, you or I might go past something and say, "Oh man, that concerns me." 5 in 3 days, is a little
Right.
bit, and all of them turned out to be false, is concerning.
Right.
So,
Right. Now,
anyway,
that's why the police do investigations.
that
Right.
is.
But it is a good one for your discipline class to say, you know what? Look how bad this looks on paper. But on the other hand, if you investigated, maybe what you would have found is he really did see these things. He's just hypersensitive to them.
And you know, maybe there was an investigation because it was the fire chief who reported it. So the chief might have said, call the kid and say, "Hey, what's going on?"
Right.
And oh yeah, well, you know, another thing that concerns me, only because a lot of my clients are volunteer departments and they have certain incentive programs. And when I see something like this, I am wondering whether it's I've got to get so many calls in to get off probation, or
Could be.
I'm going to school and I've got a job and I can only be available at certain times or certain days, and I've got to get those runs in or whatever it may be. So
Could be motive. Could be motive.
yeah.
But police issue. Okay, let's go to North Carolina, where we have firefighters filing a suit. Now, I don't know if they have paid on call. Does North Carolina have paid on call here, or is this not?
It could be. I got the sense that these were paid firefighters, that they were working shifts. They were working what they referred to as the Charlotte schedule. And
okay, so that's
so
just scheduled, right? That's not paid on call. And
No,
well, and for the viewers, what they're doing is they want overtime because they're only getting paid for 40 hours, which begs a question. Let me throw out the question, not the answer. The question is, okay, the fire department was able to use the FLSA 7K schedule, but didn't. They clearly could have. Let's assume for the moment, because I don't know the facts here, that they didn't set it at above 40, even though they were entitled to do so. Here, presumably, they would be arguing, well, you didn't set it, you didn't take advantage of the exception, so we are due to be paid over 40 hours.
Well, there's another issue here in that the 7K exemption is only for public agencies. And this is a 501c3 private sector entity. They cannot use the 7K exemption. This can be a problem where you have a volunteer fire company and they see a next door neighbor that's paying their firefighters overtime in accordance with the 207K exemption, which is 53 hours a week or 212 hours in a 28-day work period, blah, 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 blah. But bottom line is they say, oh, that's how they do it. That's how we'll do it. And you can't, because you're a 501c3 and they're a governmental entity.
Yep.
And I think that's the crux of this case.
So I think that's going to be that. Look, they're going to lose if they're not paying you 40 over 40 hours, the overtime. They presumably may lose.
If you're a private sector entity and you have employees, you've got to pay overtime after 40 hours in a 7-day work week. You cannot extend it out to 28 days. You know, it's unfortunate, but that's the way it is.
Cool. Okay, to a state that actually protects their people, unlike New York, welcome to Florida. And Florida has, it's called the HALO law. I have some real interest in how it's going to be enforced on a case-by-case basis. But basically what this says is, if a law enforcement officer, a firefighter, or EMS personnel believes that someone has the intent to harass them, threaten them with physical harm, right, or interfere with their duties, the first responder gives a verbal warning, and then the individual has to stay back, I think, 25 feet from them so they can do their duty. This is begging firefighters and EMS to wear cameras. If you don't, how are you going to prove you gave them, right? And so now it is your warning. And by the way, they'd be charged with a felony, right? I think it's a felony here. So how do you prove that a verbal warning was given?
It's a misdemeanor.
Misdemeanor, sorry, right? Yeah. It is a second-degree misdemeanor. So how do you prove that the verbal warning was given? And to me, you better have something like a body camera on you right, or a bunch of witnesses that, the person didn't back up, and then 25 feet from what? 25 feet from the person, 25 feet from the scene, 25 feet from another first responder who didn't give the order. So when I see these things, I immediately go into legislation drafting mode, which my father did forever. And so we always used to talk about and deal with it because he was in state Senate for many years in New York. I look at this and I like, okay, well, wait a minute. What is physical harm? Right? I'm just looking at words they use, right? Do they define physical harm? Do they define harass? Right? Is it harassment to say, help, I really need help, and to say it 5 times? And then somebody says, I told you to stand back. I'm like, but I'm begging you for help. Is that harassment? I would argue no, right? And that is what is impede and interfere. So when you use these words that do not have common sense meanings in all respects, I start to worry about the ability of this law to either A, withstand scrutiny, or B, be enforced actually against anybody. Yeah, but I love the law.
And that's essentially a due process argument, that it's vague and ambiguous, and it's kind of like conduct unbecoming. It's like, what exactly is it? So you've got that due process argument. I can see also a First Amendment argument in that you're preventing people from voicing their concerns and bringing their concerns to the people who are about to arrest a family member or about to possibly beat someone, right, that they feel like they have a right to intervene. So I can see possibly the ACLU or other entities that are out there protecting civil rights possibly challenging this. In fact, I would be surprised if George Floyd didn't. Now, maybe it will pass, maybe it won't. I like the idea of it. I like the concept. I'm not sure that this is going to be the solution. Have you seen any other states that have adopted a law like this?
Well, this is part of the reasons I raise these issues. So New York State has adopted a series of these in a much different manner, because you have to actually have physical contact. And the physical contact has to result in a harm that you can see. A mere push is not enough. So pushing someone down the stairs is one thing. Pushing them away from you is not. So
are you talking about the police officers have to push, or the citizen? Like, let's use a stereotypical one where you have a male that is being apprehended by the police, and you have a female that is in a relationship with that person, and that person is within the 25 feet and is yelling at the police officers, don't arrest my boyfriend, don't, or filming or whatever it is. Are you saying in New York that the woman has to touch the officers in order to violate it? But I would think that would be an assault. If she puts a hand on the police officers, that would potentially be an assault already.
Yes, you would think it is, but and I should bring it up. I know it's in my book a couple of places, but the New York state law requires more than just yelling.
And right? It would be obstruction, possibly obstruction as well.
Yes. But it takes more. I couldn't tell you about other states, but I think verbal stuff is going to get very difficult to prove, unless it's, I'm going to kill you, I'm going to write that type of thing. That's tough to prove. And then to your point, like, go to the George Floyd scenario where there was a paramedic who was a first responder in name or in normal job, but she wasn't on that call. And she's like, I wish I went and helped and interfered or helped. Well, wait a minute. If you had done so, it would not have been treated kindly, right? You're not going to interfere with police taking down somebody and say, oh, stop. And the police are going to be like, oh, okay, sure.
Well, you raise a good point. Would a paramedic in that situation be a person? Now, if you look at the statute, it says 2A, it is unlawful for a person. So if you have a paramedic on the scene and a police officer says, get back, could the paramedic possibly be charged here?
Yeah, I mean, right? Why couldn't they? Why couldn't they?
All right, let's take it a bit further, only because I have relatives that are in law enforcement. If you have a police officer and you have another police officer, maybe from the same agency, maybe from a different agency, could a police officer charge a police? I'm getting to the level of absurd.
But you raised the right issues, and these are the issues that people have to ask when these new laws come into play. Were they written in a way that people thought of? Right. So we don't have that type of issue. Well, I'm going to arrest. It's a police matter. I say it's a police matter. And I'm going to arrest the EMS person.
We know, and I track police officers arresting firefighters. We know that that happens unfortunately way too often. My sense is occasionally police officers do arrest and charge other police officers. And that does unfortunately happen. A lot of times it doesn't, certainly I don't cover it, but we know that it does happen.
So I'm just pulling up New York State, because New York State generally copies other states. A lot of states do, right? And there's a number of them, but they have a newer one that's come out, which says it's part of the penal law, so it's criminal, that it prohibits obstructing firefighting operations. And here, a person's guilty of obstructing firefighting operations when they intentionally, right? So you don't see the word intent here that I've seen in Florida law, but when they intentionally obstruct, hinder, or interfere with firefighting operations. So there's a couple of cases on it. This is the older one, but I think the courts came out and said you have to physically touch somebody and physically, put your hands on them, and in a way not that's minor. And
I think we've all seen the videos of a police officer trying to apprehend someone or trying to deal, and then these other people start getting in and yelling and screaming and accusing the cops of doing something that they shouldn't be doing, and so on. So
right. So there are states that do this, but I think this is a good attempt. I just think they need a little bit more in it. So some of the definitions, right? Like harass is there in the Florida law, right? To willfully engage in a course of conduct directed at a first responder, which intentionally causes substantial emotional distress. Now, stop that for a second. Does that really need to be?
A good firefighter does not have substantial emotional distress. You can't rock
no
them.
Emotions.
You can't rock, there's nothing you're going to do that's going to rock me, guy. Come on.
I've got an axe. You've got your voice. I win. And I'm not going to be harassed. But I mean, that's a kind of ridiculous thing. Did you, I like New York's law. I don't think I ever said this, but I like New York's law better than Florida law, right? New York's law focuses on the act and the conduct. Florida's law appears to focus on the result, the effect, right? And come on, a firefighter having substantial emotional distress.
Oh, I was so upset.
Right. Come on. Right. You're never going to state that you were, because when you get back to the firehouse, you're going to be ripped to shreds. So anyway, okay.
The intent was good. The intent was good.
Yep. The next one I really like a lot. We're back to New York. We're in a place, it's Long Island, Suffolk County. So the end of the Long Island, Wading River, New York. Now, just to be fair, I know Wading River because we were just successful in a lawsuit against them when they removed the chief from office. We covered it. On our blog, on the blog. We got a good, Wading River Fire District moved to dismiss the case. The motion was denied. In any event, but here's what we have. And I just want to say that this is not new in Suffolk County. So here's the facts, and then I'll give you my thoughts on this. So there's citizens from Wading River, again, Suffolk County, New York, which is also is within the town of Riverhead. And there is a cell tower being put up, as happens all over the place. And I'm sure this happens all over the nation, but in New York, at least, cell tower companies will approach a fire district or a fire department to put a tower on their land.
Mhm.
And typically when I'm the attorney, I say, okay, well, is it, do we have a state environmental quality review analysis called SECRA, but it's an environmental review you've got to do. You're putting a tower on your land. It could affect birds. It could affect electromagnetic spheres. It could affect a lot of things, views, visual, environmental quality in a lot of different ways. So you've got to do that. But here, they're alleging that they did not get a zoning change. At least that's how I take away what I see, is that it sounds like the citizens are saying you put this up, but it violates our zoning ordinance, and we should have had the opportunity to challenge that or at least get our input. Now, here's the thing. What a fire district is exempt on something, I'll explain it, called the Monroe test, but is presumed, almost presumed exempt from zoning. And if you put it on district land, they're in charge of the environmental analysis, and the district is in charge of their zoning in this case. And again, they're exempt from zoning. You can build a firehouse in any type. But here they're putting something on their land. And so the question is it their cell tower? The way we normally get around this issue is we put a radio antenna for the fire department, always as a condition, on top of the cell tower. These are things I do daily. But I would never say don't have an environmental analysis. Just take it off the board. But so the citizens have said, listen, we have the right to speak up against this massive tower, which is a for-profit entity sitting on, I presume, fire district land. So now you have a for-profit entity, which is not exempt from zoning, on a land which is exempt from zoning, and that's the question you have. Now, I am aware that, and so they want, I think the tower's up. I couldn't tell. Could you tell whether the tower's already constructed?
I couldn't, but they are seeking to get the project stopped. So
yeah, so they are not off the rocker. Let me start with that, because in Southampton, which is right next to them, within 20 minutes or so, as I recall, about 5 years ago, there was this exact same case in Southampton, and the town put it up anyway. They put up the tower and they said, we're not doing the environmental analysis. We're not doing all these things. And they lost, and they were ordered to take as I recall, they were ordered to take the tower down. And these are not cheap, right? These are massive. They're either monopoles or they're actual towers. Long Island has a lot of monopoles. Long Island also accommodates by putting trees on top of the tower. So it looks like a really bad fake Christmas tree, but they do. And it hides it. You just get this massively tall tower with trees at the top. It's a little weird. In any event, it does look a little better, but these are all over Long Island, all over. Most of my fire districts that I represent there have them on their tower, and they get paid, or on their land. They get paid good money, but you got to go through the process. So the court here is going to answer for me, I hope, a lot of good questions. First question, is a private entity that puts their structure on public land, which is exempt from zoning, do they get the benefit of the zoning exemption? And normally you would say no, but here, if the district puts a radio antenna on top, what's the analysis? I don't know. I haven't looked into this because I've never made this mistake. But
well, you have a question about whether or not the tower it's paid for by the developer. No question about that. Right. Who owns the tower? Now, if the fire department owns the tower and they lease space to the developer,
correct.
That's one thing. If the developer owns the tower and allows the fire department to have an antenna, but then pays them royalties or whatever you want to say, or lease or whatever, for being on the property, that's a different thing. And there may be, depending on how you characterize the relationship, there may be some variation in how it's going to come out.
Yes. And look, there are ground leases, right? And when it's a ground lease, you're leasing space either for the generator and the control box, or sometimes you're leasing the land for the tower, which in case, if you're doing that, you're probably done here. You lose, right? Because it's not your tower. If it is your tower, normally they reserve you, it's called sublocation, right? They sublocate usually up to 4 other, a T-Mobile, a Verizon, AT&T, whatever, up to 4 others usually get sublocated onto the lower ports of the tower. But a lot of times that has to be approved by the district. So you're right. It depends who owns it. And we don't know necessarily all of this, but it's a great question for the court. It's a great lesson for attorneys. And my answer here is, if I was the attorney and I faced this lawsuit, I would go back to square one and just do all these hearings now. No harm, no foul. Have the hearings, because with most of this, it's still up to the planning board anyway. They just want their public input and maybe a chance to appeal it. But a lot of times there isn't going to be the chance. So,
okay. If the, both the town council obviously has to approve of something like this. They're somehow involved in it. They have town meetings. The fire district has fire district meetings. They have agendas. And so obviously these things were on the agenda both at the town and the fire district. Wouldn't that give someone who has a beef about something the opportunity to raise the very concerns that they're saying that they've been denied? Yes, it's not the same as a zoning meeting. Yes, it's not the same as a planning board meeting, but it still is an opportunity. That what they're arguing is that they have no opportunity for input. Well, that's not necessarily the case.
Yeah, and I don't know whether they said it should have gone to the town or it did go to the town, because if I was in charge, so under the environmental analysis, that can stay with the fire district if it's all in the fire district's property. They can be what's called the lead agency for the environmental analysis.
Okay, but their board still has to meet and discuss it, right? And that
of course,
right,
and that public notice has to be
public notice and
yes, but there doesn't have to be a hearing. We could start down the rabbit hole of a unlisted action, type 1, type 2 action under New York State's environmental stuff, getting very state specific, but there doesn't always have to be a hearing depending on what type of issue this is. Now, zoning changes, right? You can avoid the whole need for a zoning change if you perform what's called the Monroe test. And the Monroe test says, listen, a public entity is building something to be used for a public purpose. Although it's not automatically exempt, all the town has to do is exempt it. And it's all but a foregone conclusion. If you're building a firehouse, an antique barn, a storage facility.
But wouldn't the vote on that still have to be at a public meeting?
At a public meeting, but not a public hearing. Meeting versus hearing, different. So the meeting doesn't require that you take public input. The hearing, it does. So that's the distinction. And it's a distinction with significance. But on the other hand, just do it now. Right? Just do it now. I mean, to fight this is silly. And what you're going to get is you're going to get one law firm who didn't create this problem saying, oh, we're going to drag this out, as opposed to just fix it. And I'm not saying that's what they're doing. I don't know what the law firm is handling it. I haven't looked at it, but I would be saying, just go back and fix it. And then you can tell the court, we did it, nunc pro tunc, as if we did it on the first day, it's done. I don't know, but they should be careful, because in their area, again, I think it was Southampton right next to them. They lost. That town took the ignorant approach, saying, we're going to stick by our guns. We're not going to fix anything. We didn't need to. And the court says you're done.
I wonder what the cost of that. I wonder if the fire department had to eat the cost of that.
Well, that one wasn't a fire department thing, but that was a town issue for the cell tower. But either way, same issue. Yeah. If it was me, just mea culpa and fix it. Yeah. So, okay. And lastly, is this lastly? I think it is. Yeah, we're going to go to California for a more in-depth one. It's funny how our shorter cases take much more of discussion, which I really like. So we have an appellate court, right? The second highest court in California has now reversed a court. And I think we covered this.
I think we did. Yeah, I think we did.
So the original trial court now reversed, dismissed an age discrimination, and of course always goes to discrimination, retaliation lawsuit brought by a fire captain. And the fire captain was arguing that you discriminated against me based on my age. And the trial court, though they performed what we always talk about as the burden shifting McDonnell-Douglas test, the trial court agreed with a lot of, the appellate court agreed with a lot of what the trial court did, except came to a different conclusion as to one factor, which was basically the justification. right? Was it pretextual? Did they fire somebody or did they not promote somebody in this case based on a BS type of argument or on a real argument, right? And BS is non-legalese for pretextual. So was it a fake argument or was it a true argument? And the trial court said, no, you're dismissed the case. The appellate division reinstated, saying that a jury could conclude that the municipality discriminated based on age, based on a bunch of factors. They talk about comments that were made, prior non-promotions that were made. They brought in past people who retired, who said, I was subject to discrimination, phrases that were used, hey, you're the old guy around here, get on the bus, we're going to leave you behind, and all these old guys type things, statements. So there was enough to lead that a jury could reasonably conclude that age was a factor in the decision not to promote. I'm a little surprised that the trial court got it wrong in that instance, because it doesn't take too much to create a question of fact on a pretext question. Right. I mean, and we saw this exact case filed now with the old age, et cetera. We saw a very similar case where they're asking other people about one of the possible promoters' age, right? And they asked that guy about his age, and you and I were like, "Do not talk about age. Don't ask the question." What we said, this is only 2 weeks ago or so, right? And what we said was, because you're giving pretext, you're showing that there might be a reason, and the trial court didn't find it influential enough that those statements could show pretext. But pretext is a question for a jury. It's not a legal issue. And as soon as they raise something that a jury could find you discriminated, you got to let it go to the jury. You can't dismiss it before that.
Yeah, I think if I have one criticism of courts today, it's that they seem to be playing keep away when it comes to letting issues go to the jury. And if they can find any excuse not to let it get to a jury, they'll try to decide it that way. And I think what the court is saying here is, it's a weak case, but it's a case that really needs to go to the jury. And I want to make one comment. You mentioned the bus comment, and that stood out to me as well. And the reason why is I went through EFO 93, 94, 95, 96 in that era. And one of the instructors, I remember the instructor talking about leadership, and that when you're trying to really engage in transformational leadership and take an organization that's maybe stuck in the past, use the metaphor that, look, what you say to your older chiefs of people who are sort of stuck in their way is that there's a bus coming, and you can get on the bus, and we'll give you a drink, and you get on the bus and you go in the back and, or wherever you want to sit and, have some, have a beverage and just stay on the bus. Or you can stand in the road in front of the bus screaming and yelling, the end of the world if we change anything, And he used that metaphor. The reason I say this is not the first time I've seen a comment about get on the bus. Right. In lawsuits. And I do wonder whether or not some of the folks who maybe made those comments had been through the EFO program, or maybe had listened to a lecture by someone who'd been through the EFO program, or somehow had been taught in a leadership class to use that get on the bus metaphor, or stand in front of the bus and try to stop the bus, in which case you're going to get run over. But
that's a question of fact for a jury, right?
Well,
not for a judge.
It is. But I think it's unfortunate when we have well-intentioned instructors saying, using something like this, and then well-intentioned students saying, oh, well, yeah, I'm going to tell my guys, you either get on the bus or you're going to get run over by the bus, Right. And then that ends up in a lawsuit because it's ill-advised when somebody's in a protected class such as age, and now you're telling them get on the bus, or you're going to, and I don't know, they didn't mention getting run over, but that's the other part of that metaphor. You're either going to get on the bus, put your feet back, have a beverage and enjoy the ride, right, or you're going to get run over by the bus.
And maybe that's what was meant. Maybe that's not.
Yeah, and we don't know, but I just to my colleagues out there who've been through EFO that might have heard a reference to that type of a comment, we have to be very careful in the choice of language and the choice of metaphors that we use, because they can come back to bite you in a case as is the case here.
You know, it's interesting as two of many people who do a lot of lectures around the nation, right? I mean, I'm now wondering, like, I wonder if I say things that get repeated that way.
We got to be careful, but a metaphor is a metaphor. But, when you're actually in front of someone who, potentially is going to object to where you're going and may bring a legal challenge, you really maybe want to think through the metaphors that you use.
Absolutely. Absolutely. And, look, if you're a individual in a fire department, don't comment on somebody's age, sex, race, etc. Religion. There's just no reason to do it.
Don't ask.
Yeah, just don't say anything like that. It's a very simple rule. If you want to say it to a 6-year-old, don't say it. I mean, it's simple. Just don't violate that rule and you won't ever get in trouble. If you wouldn't tell your own 6-year-old or somebody else's 6-year-old something, don't say it to one of your firefighters and you will you won't get in trouble. Sorry. Anyway, okay. Well, that is our cases for the week.
All right. Well, that'll do it for this week of Fire Law Roundup. Please help us out. Please subscribe if you haven't already subscribed. Please click like and share and help us out that way. And that'll do it for another edition of Fire Law Roundup.